Adjourn.
All right. Good morning. This is Chair Douglas for the record. We will call this meeting formally to order. If we can have our roll call for purposes of a quorum.
Thank you, Chair. Member Jerry Merritt.
I'm here, thank you.
Member Dennis Nylander.
Present.
Member Rihanna Durrett.
Present.
Member Young.
Here.
And Chairman Michael Douglas.
Here.
Great. Deputy Bala, can you please confirm that we have complied with the open meeting law requirements?
We have, sir.
Great. Well, Chair, with your approval, we can start by moving to agenda item number 1, which is public comment. Do we have anyone in Las Vegas wishing to provide public comment at this time? Thank you. Please state your name for the record.
Frederick C. Draper, I'm here to make known to you the wave that's on the way and is outside of this. What it is the American Disability Act of 1990 prohibits discrimination based upon disabilities. Businesses and organizations with public services and spaces must provide accommodations and equal access for people with disabilities. If they fail to do so, they can be held accountable in court for violating civil rights laws. Websites have been deemed to be virtual public spaces. Websites must comply with the ADA regulations as well. Cannabis and CBD businesses must take greater precautions, especially those without brick and mortar locations. As such, their websites, consumers only come there and have no means of accessing their products or services. Many cannabis and CBD businesses have failed to provide this accessibility, and the industry has experienced a wave of lawsuits as a result. The ADA and the WCAG outline standards to properly accommodate website users. If cannabis and CBD businesses fail to meet these standards, blind or virtually impaired persons consumers do not have an access to their products and services. But complying with ADA regulations is not easy because the Justice Department has not officially created guidelines. Additionally, updating an entire website to meet ADA standards can cost thousands of dollars. As a result, at the risk of lawsuit, however, is not worth the attempt of saving money, since many businesses have been sued multiple times in recent years. While complying with ADA standards may be not quick or a straightforward process, it does protect cannabis businesses from potential lawsuits. It opens cannabis businesses up for more potential revenue, and it keeps cannabis businesses from unintentionally discriminating against their customers or clients. I'm with ADA Site Inspector, and we do comprehensive website evaluations of the websites to make them compliant to the ADA. So that's presented to you this morning.
If you have a card, if you could leave it with one of our staff members, we'd appreciate that. Thank you.
Thank you. Is there anyone else in Las Vegas wishing to provide public comment at this time? Please come up and state your name for the record.
Sorry, actually, for being late. My name is John Stokes. I represent Smoke Whiffs, which is a concept that I wish to bring to Las Vegas. Excuse me. It's not that I want to bring attention to some of the blind spots that I think this committee has kind of overlooked. One being that social equity seems to, I'm actually out of breath because I kind of ran up here, excuse me. Social equity seems to be a little discombobulated here, because what we're looking to do is we're actually looking to find equity. The equitable area here is, excuse me again.
Take your time.
I will wait for after, I know there's public comments afterwards. It's probably the coffee and the water, but I will, thank you very much.
Just as a side note to part of your comment, we are a creature, this board is a creature of the legislature. And until this last round of legislative activity, social equity was not put on the table to be considered. It's presently on the table to be considered as the opening of consumer lounges. But not to take away from what you have to say later. Thank you.
Thank you. Is there anyone else in Las Vegas wishing to provide public comment? Is there anyone in Carson City wishing to provide public comment?
Nobody in Carson City.
Thank you. Chair, with that, we can move on to agenda item number 2, the approval of the meeting minutes.
We have in our packets meeting minutes, the A item, consideration for approval of September 14th, 2021 Cannabis Compliance Board workshop meetings. And additionally, item B, consideration for approval of the September 28th, 2021 Cannabis Compliance Board meeting minutes. They are on for possible action. They've been provided in our information this day. If members have read them, if we can get a motion for approval or corrections and necessary amendments, either or, whatever is appropriate.
I move to approve the September 14 and September 28 minutes.
We have a motion for approval. Do we have a second?
This is Member Merritt. I second.
We have a motion and a second. Any additional discussion? Any corrections to be offered? Hearing none, all in favor of approval of the minutes as to September 14, 2021 and September 28, 2021, please say aye.
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 Aye. Motion carries unanimously. We move to item 3, consent items. If we can have our staff team provide the information as to complaints.
Thank you, Chair. So 3A on the agenda concerns 2 complaints today for disciplinary action pursuant to NRS 678A510. The Attorney General has reviewed these violations and recommended proceeding with disciplinary action. I'm requesting board approval to proceed with each of these 2 disciplinary actions. If approved, I will then authorize service of the complaints. As service is now in the hands of the Executive Director, we are not required to immediately serve both complaints today. Once the board's approved proceeding with disciplinary action, service will proceed within a reasonable time, and I anticipate, if approved, both complaints will be filed in the next 2 weeks. Once they're out for service, CCB will post them on the website. So now present the violations alleged and request the board vote to authorize proceeding with disciplinary action against these 2 respondents. As to respondent A, the complaint will allege violations of NCCR Regulation 4 and NCCR Regulation 11. As to respondent B, the complaint will allege violations of NRS 678B, NRS 678C of Title 56, violations of NCCR Regulation 4, Regulation 5, and Regulation 6. So with that, Chair, I'll turn it back to you.
And note for the record, we have 2 proposed complaints that are being offered today. Pursuant to statute, the board has not seen or is aware of the violations except for what's been provided this date in the open meeting. Our approval is to go ahead and serve that the department and the Attorney General's office have had revised statutes for preparing those. With that, can I get a motion for approval?
Member Durrett, I move to approve the issuance of the complaints under agenda item 3A.
Okay, would you like to double it up and go for A and B, or?
Under agenda item 3A, I move to approve the complaint, service of the complaints against respondent A and respondent B.
Do we have a second as to that?
This is Member Young. I will second that.
We have a motion, we have a second, we have any discussion? No discussion. All in favor of the authority of the directive to proceed with service, please say aye.
Aye. Aye.
Any opposed? Any dissent? Hearing none, matter's been carried unanimously. We now move to item number 4, consideration of effective date for extension granted at the September 28th, 2021 CCB meeting.
Chair, thank you. So this item is a follow-up to the action taken on extensions by the board at the last board meeting. What staff would like to do is just clarify on the record when those extensions are effective from. I believe some of the motions were the date of the meeting. The request came in from February 5th, 2022, which is the final date that licensees need to be operational, receive their final inspection. And so, again, just looking for clarity on the three motions to ensure that we are sending the right correspondence to the licensees on the extension.
Discussions or comments by the board? The motion has been brought back, or the extensions have been brought back to the board because there seemed to be a disconnect in communication as to the extensions request. We considered the board last time, and the amendments are clear, that the extensions be from the date of the last meeting. And we set that forth. What the staff was expecting was to go from the end of the calendar year and then to go forward. So the question is whether or not we wish to change that or to stay with what we had proposed previously. For me, the only one that I was possibly concerned with was item C, HSH, which was 6 months from the day based upon what they had provided. But having said that, and I understand that this would have started from, I guess, the end of what they have now, which is February of 2022 and going forward. So considerations or positions of other board members in terms of what they would like to do, if they want to go ahead and correct that as requested or leave it as it is.
Member Durrett, for the record, I think it makes sense to move them to beginning on February 5th, 2022 instead of September 28th, just to make sure. That's what I had in mind. That's what I thought we were passing at the time.
Anyone else wish to weigh in?
Mr. Chairman, if I may, I just wanted to state for the record, this is just a clarification, as you noted, and so we're not making substantive changes to the underlying decision that was made before, just for the board's edification.
Well, what we have is the board minutes that are in the record are very clear in terms of what the board did last. And the board was very clear to state it was from a date certain. So we are in fact changing to a certain date the timing of this matter and when it is effective. So that just plays squarely what we are in fact doing. So we'd be move them. Their running dates are 12 months and 6 months to start at the conclusion period that they presently have, which goes into the beginning of 2022. If no other discussion, I'd make a motion to amend our starting dates to the expiration date beginning in February of 2022 and going forward.
Mr. Chairman, this is Member Nylander. I would second that motion.
It's been moved and seconded. Any additional discussion? Hearing none, all in favor, please say aye.
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 Aye. Any dissent? Any nays? Matter carries unanimously.
Thank you. We'll move on to agenda item number 5. This is the request for transfer of interest. We'll now turn it over to Chief David Staley to present this item to the board. Chief Staley, when you're ready.
Good morning. Chair Douglas, Member Merritt, Member Nylander, Member Durrett, and Member Young. For the record, I am David Staley, Chief of Investigations for the CCB. I'm here to present agenda item number 5, which consists of one transfer of interest or TOI application. Item 5A is a TOI application for Urban Hills LLC or Urban Hills. TOI number 17004 requests approval for internal transfers resulting in Dustin and Crystal Pebbles together owning 100% of the company. Staff has identified areas of concern with this application. Staff has reviewed the annual renewals filed by Urban Hills since May 22nd of 2017 and compared them to the original TOI filed on April 17th of 2017 and the amended applications filed on September 8th, 2018 and August 11th of 2021. After review of the information submitted by the applicant, staff identified 4 different apparent transfers of interest that have occurred without prior CCB or its predecessors' approvals. In addition, staff identified 28 late filed tax returns during a three-year period from October 2018 through October of 2021, apparent violations of both NAC 453D 905C and NCCR 4060. Staff has identified 5 potential courses of action in the report for this application. The first is that find that there's no violations and grant pending transfer of interest. The second is find there's not enough information to grant or deny the request and request further documentations and or briefing before hearing the matter again in future CCB meeting. The third is find that there was an improper transfer of interest completed prior to the request for approval and or additional regulatory violations. Deny the request for TOI approval and direct the executive director to transmit details of the suspended violations to the Attorney General's office for further investigation under NRS 678-500 sub 1. The Attorney General shall review potential violations, including at least 4 Category 2 violations for failing to notify the CCB of a change of ownership and or at least 3 Category 5 violations for failing to submit monthly tax or sales reports or payments. Such violations could result in revocation, suspension, and or civil penalties up to a maximum amount of $80,000. The fourth would be conditional approval of the TOI on the stipulated agreement of Urban Hills to admit certain violations and accept civil penalties up to the amount of $80,000 for one or more of the violations set for in option number 3. If this option is taken, CCB may direct staff to work with the Attorney General to draft a mutually agreeable stipulation and order with Urban Hills for CCB approval at a future CCB meeting. The fifth is find that certain violations did occur and request the licensee negotiate with the Attorney General's office to find a mutually agreeable settlement between CCB staff and the licensee to be approved later in CCB with a complaint to be filed if there is no such resolution. My understanding is that the licensee is appearing before you today, and they would like to request to refer the item back to staff to explore the option of returning the item back to staff with you to give them an opportunity to work with staff to further explain their situation. I am available for any questions, and my understanding is that Dustin Pebbles and Crystal Pebbles are present in Carson City to provide a brief presentation to the board and address any questions you may have as well. With that, Chair Douglas, I'll turn this item.
Thank you. We can have the applicants forward on the mic, please.
Good afternoon. Where should I be looking?
If you would identify yourself.
I'm Dustin
Please.
Pebbles, CEO of Urban Hills.
I'm Crystal Pebbles. I'm CEO.
And would you state your position for the record, please?
I am Chief Executive Officer of Urban Hills, and my wife here is the operating officer. We believe that we had submitted the proper documentation to the Department of Taxation in 2017 for any transfers. And the spirit of our contracts at that time had all leaned on the notion that no subsequent transfers would be valid without uh, prior consent of the CCB. It has come to our attention in discussing with Mr. Staley that there are some areas of concern. And as of yesterday, this has just been made aware to us. So uh, we would like the opportunity to circle back and have some discussions with them and provide them further information that they might need so that we can get better clarification as to where we may have went wrong and or what we can do to solve the situation.
You heard the information provided by the CCB staff as to areas of concern, one being a tax item, but the other as to transfers of interest, and at some points a question of hidden interest, the way things have been provided. These are serious concerns for CCB to consider. I, for one, after looking at this, almost want to refer it for a disciplinary. I'm willing to give you some additional time to sit down with staff and provide the information they had previously requested. But you should not take what they requested lightly, because they've asked you in the past to present information and they really got nothing from you. That's just not acceptable.
I'm sorry, sir.
That's my comments. Any other board member wish to ask questions or weigh in at this time?
Yeah, Mr. Chairman, this is Member Nylander. Question for the applicants. Presently, it appears that the sales and use tax return for August is still delinquent. Are you aware of that, and why have you not paid your taxes?
I believe we pay them every single month at the end. We have appointments go in, we pay them at the end of every single month. I am very unaware that they are not paid. I mean,
they should be paid.
They should be paid. My general manager makes an appointment every single month. At the end of the month, she goes in, it's on our books, they're paid. So yes, that's why we're very confused and would like to circle back and talk to them, because we have provided them with a lot of information. We provided them with, any request that they've given us. So I'm surprised to hear that we haven't, I've been discussing, I've been working with Danny for a couple months now, and I've given her, a lot of records. I've been working with her, talking to her on the phone. So I'm very confused to hear that we haven't given them any documentation, because I've given her probably hundreds of documents through Dropbox and, through email.
Yeah, so, well, just so you know, our records indicate that there are 28 delinquent returns, including the most current one. So that you guys are gonna have to figure that out.
Right.
28 delinquent returns, in my view, is that's a very serious problem.
I'd agree. To our knowledge, we paid every single one and every single tax return and filing possible.
As far as I believe, we've had maybe 3 late that we paid penalties and fines on, but that's it in the entire 3 or 4 years that we've been in business. So that's why we'd like to circle back and talk to them and see where we're going wrong here.
Well, I mean, our records again indicate it's 28, not 3, including the current return. So.
Questions by any other board member of the applicants? In light of if there's no other questions.
No, I apologize. I'm not here to tell anybody that they're incorrect. It's our primary position in what we do is to ensure compliance with tax commission, CCB, and ensure that all of our bills and debts are paid. And we believe by and large we're timely with all of those payments, and that we don't have anything outstanding at this time. It is a surprise to me to hear that there is a number such as 28 that you're delinquent. I'm assuming when you mentioned delinquent, you may be meaning late in the sense of a day or something like that. But I would hope that we don't have any outstanding balances with anybody.
Thank you. Mr. Staley, as to the request to sit down with you or members of your team to go through this, what kind of timeline would you look at before this came back to us needing?
Chair Douglas, David Staley for the record. I don't know, we could try to get it back before you on the November agenda, but because of the holidays, the schedules are a little bit compressed. Certainly the applicant has indicated, they'll work with us, and I'm sure they will. I think that it may be appropriate to look at the December agenda on this one, because of the compressed timelines. Both the November agenda and the December agenda are early in the month than you would typically see on your schedule. I think it would be appropriate to bring this item back for your consideration on the December agenda.
All right. Having heard that response, any additional questions by members of the board, Mr. Staley? Hearing none, I would make a motion then to hold this item until our December meeting. That would be my motion.
Mr. Chairman, this is Member Nylander. I would second that motion.
Thank you. It's been moved in second. Any additional discussion? All in favor of the motion to hold until the December meeting, please say aye.
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 Aye. Any opposed? And any abstentions? Motion carries unanimously. Note for the record that local jurisdiction where this operators operating had no concerns in terms of how they were running their business in that locale. But with that, we do have some concerns, and hopefully they can be clarified for our next meeting. We would move our agenda to item 6, consideration of proposed settlement agreement to resolve disciplinary actions.
Thank you, Chair. So agenda item number 6 will be presented by Senior Deputy Attorney General Chris Rath. So Deputy Rath, when you're ready, please proceed.
Thank you, Executive Director Clemens. Chair, members of the board, good morning. L. Christopher Rath, Senior Deputy Attorney General. We have 2 settlement agreements up for approval at this meeting under agenda item 6. As usual, I will provide you with a brief summary and the Attorney General's recommendation for approval of each. You may then ask me any questions you wish. Counsel for the respondents will also be present to respond to any questions you may have. You may then decide on the action to be taken for each. With that, I will go ahead and move forward with agenda item 6A. The first settlement agreement is for the case of CCB versus NLVG LLC, case number 2021-40. This complaint was filed and served on July 27, 2021. Respondent undertook settlement negotiations with the Attorney General's office after they retained counsel and prior to filing an answer to the complaint. Prior to filing an answer, the parties came to an agreement to resolve the matter that is mutually agreeable to respondent, CCB's staff, and the Attorney General's office. Parties agreed to a stay of the disciplinary process while the CCB considered approval of the settlement agreement before you. The events at issue occurred at a cultivation facility in North Las Vegas in April 2021. The allegations in this complaint include a failure to tag cannabis plants as required, a failure to wash and sanitize cannabis product contact surfaces, infestation by pests, improperly stored cannabis, and a failure to fully maintain a proper surveillance system. As set forth in the proposed settlement agreement to resolve this matter, respondent admitted to 1 Category 2 violation for failure to maintain a surveillance system, 1 Category 3 violation for failing to tag plants, and 2 Category 4 violations, 1 for improperly stored cannabis and the other for allowing infestation pests. Respondent also agreed to pay civil penalties in the total amount of $48,000 with the option to pay in installments. Respondent did provide a plan of correction, which is summarized in paragraph 20 of the settlement agreement, and CCB staff has approved this plan. The plan of correction includes NLVG's confirmation that the security camera at issue no longer has a blocked view, and that NLVG has now tagged all the plants that were at issue and that were a problem. NLVG has also properly destroyed the loose pieces of cannabis found at the facility during the subject inspection. Also, NLVG has instructed its staff on proper cleaning and disposal of cannabis waste. Finally, NLVG has also instituted policies and procedures to ensure that they maintain proper pest control. Based on this, the Attorney General recommends and requests that CCB approves the settlement agreement. I am available for questions, as is counsel for the respondent.
Any questions by the board as to what has been proposed at this time? And if there is not, if we can hear from the licensees.
Good morning, Honorable Chair Douglas, members of the board, Director Cannabis, Derek Connor on behalf of the licensee NLVG LLC. Also with me is representative from the company, Ms. Judy Woodward. We just want to thank the board for working with us on this. They're a small grow with very limited operations, and we appreciate the consideration for that fact. And we would request that the settlement agreement be approved by the board today.
Questions by members of the board? The board is silent at this time. I just note that in the stipulation agreement that has been put before the board, in paragraph 18 and paragraph 19 in the stipulated adjudication, besides the fact that you have put forth a plan for remediation, so this does not happen again, which we appreciate. There's an outline that you're going to pay this in 4 installments, and then importantly, if in fact that's not done, penalties for failure to comply with payment plan option. Those 2 paragraphs from our standpoint, the licensee is aware of those, fully agrees to comply with that.
Yes, we have. We've advised them of that, and we've advised them of the potential penalties for being late.
Thank you.
Mr. Chairman, this is Member Nylander. I just have a comment follow-up. I want to thank Mr. Rath and his staff for especially paragraph 20. These violations as we've seen occur, and while there are monetary penalties, I'm mostly interested in the remediation and the plan of correction contained in paragraph 20. And I think that our staff, and especially Mr. Rath, has been focused on that, and I don't have any concerns that these matters will reoccur. I think they've been addressed, and so I'm satisfied.
Thank you, Member Nylander.
With that, additional comments? If not, if we can have a motion for approval of this stipulated adjudication.
Member Dredd, I move to approve the stipulated settlement agreement under agenda item 6A involving NLVG LLC.
We have a motion. Do we have a second?
This is Member Barrett. I second.
We have a motion. We have a second. Any additional discussion? Hearing none. All in favor, please say aye.
Aye.
Aye. Aye.
Aye. Any opposed? With that, the matter carries unanimously. Thank the licensees for their cooperation in this matter, and good luck in the future.
Thank you very much, and thank you very much to Mr. Rath and all your staff. We really appreciate it.
Thank you very much. That moves us to the B item.
Thank you, Chair. The second settlement agreement up for consideration is the case of CCB versus Alternative Medicine Association, LC. CCB case number 2021-4. This complaint was filed and served on August 24th, 2021. Respondent is a cultivation facility in Las Vegas. The sole allegation against respondent in this case is that respondent failed to maintain a required surveillance system. More specifically, on December 3rd, 2020, CCB investigators requested video footage for the facility for the date of December 2nd for a virtual inspection. Due to a malfunction of the system, respondent was not able to provide the requested video footage. Respondent filed its answer to the complaint on September 13, 2021. CCB assigned a hearing officer and the disciplinary process proceeded. However, during the course of the disciplinary process, the parties engaged in good faith settlement negotiations to see whether the matter could be resolved before proceeding to a disciplinary hearing. The parties were able to come to an agreement to resolve the matter that is mutually agreeable to respondent, CCB staff, and the Attorney General's office. The parties agreed to a stay of the disciplinary process while the CCB considered approval of the settlement agreement before you. As set forth in the proposed settlement agreement to resolve this matter, respondent admits to one Category 2 violation for failure to maintain a surveillance system. Respondent has also agreed to pay a civil penalty in the amount of $20,000. Again, the respondent provided a plan of correction, which is summarized in paragraph 18 of the settlement agreement, and CCB staff has approved this. More specifically, the plan of correction included a further investigation into the cause of malfunction, the malfunction which respondent has performed. Respondent's investigation found that a remote access feature allowed an individual to reformat a drive and to delete the saved video footage. Respondent has now disabled the remote access software to create a more secure system. Based on this, the Attorney General recommends and requests the CCB approve this settlement agreement. I'm available for questions, and I believe Mr. Zobrist is also available here for the licensee to answer any questions that you may have.
Before we hear from the licensee, does anyone on the board have any additional questions of Mr. Rath at this time? Hearing none, on behalf of the licensee.
Good morning, Chair Douglas, members of the board. Caleb Zobrist on behalf of Licensee Alternative Medicine Association. I'd first like to thank Mr. Rath and his staff for being very professional and helping assist through this matter. Members of the board, the licensee accepts responsibility for this error. It has corrected the problem and ensured that this will not happen again. And we would move to accept the settlement. Thank you.
And likewise, as I asked the prior licensee, you are aware of the amount of the civil penalty that you have agreed to in this document, and also payment of the late payment penalties. It's not paid timely. Is that correct?
Yes, Chair Douglas, that's correct.
And I will not take away from Member Nylander's comments that will come forward, but we note that you have a plan of correction in this also.
That is correct.
With that, members of the board wish to ask questions or weigh in at this time. If there's no questions, then can we have a motion?
Member Durrett, I move to approve the stipulated settlement agreement between the CCB and Alternative Medicine Association listed under agenda item 6B.
We have a motion. Do we have a second?
Mr. Chairman, this is Member Nylander. I would second the motion.
It's been moved and seconded. Any additional discussion for the record? Hearing none. All in favor, please say aye.
Aye. Aye.
Anyone dissenting? Anyone wishing to recluse? Matter carries unanimously. We thank the licensee and good luck in the future.
Thank you for your time.
Moves us to item number 7, consideration of proposed settlement agreement.
Thank you, Chair. And so for agenda item number 7 today, we've got Steve Shavorsky, the Chief Litigation Counsel for the Attorney General's Office, here to present this item in front of the board. So, Mr. Shavorsky, when you're ready.
Thank you so much. Chair, distinguished members of the board, my name is Steve Shavorsky, Chief Litigation Counsel for the Attorney General's Office. Before the board today is a proposed settlement agreement involving Rural Remedies LLC, the Department of Taxation, Lone Mountain Partners LLC, Mr. Jorge Pupo in his individual capacity, and the Cannabis Compliance Board. This settlement agreement arises out of the litigations that were consolidated before the Honorable Judge, now retired Elizabeth Gonzalez, and now pending before the Honorable Judge Joanna Kishner in Department 31. This would be the litigation that arose out of the licensing competition in September 2018. This proposed settlement agreement resolves a part of that litigation involving the plaintiff and counterclaimant Rural Remedies. Rural Remedies was originally joined as part of the litigation and then made a claim against the Department of Taxation. The CCB became involved in the litigation later on, and that is why the CCB is a party to this settlement agreement. It was joined by the pursuant to the court.
We
This
have a successor in interest.
correct, Your Honor, as a successor in interest to the Department of Taxation as a result of legislative change. In this settlement agreement, the parties are agreeing to resolve any and all claims that Rural Remedies may have against Mr. Pupo, against the Department of Taxation, and against the Cannabis Compliance Board. The main consideration of the agreement is a conditional license transfer from Lone Mountain Partners LLC to Rural Remedies LLC in the Lander County jurisdiction. As part of the consideration of this agreement, the state of Nevada will be paying $40,000 from the Tort Claims Fund to Rural Remedies in exchange for a dismissal of the complaint and any administrative appeals administrative claims arising out of the September 2018 licensing rounds that they may or may not have. With that said, General Ford's team believes this is a good settlement agreement, and I would recommend it to the board for approval.
Questions by the board as to this proposed settlement?
Just to clarify, Mr. Chairman, the CCB is not a party to the litigation, correct?
Thank you for your question, Member Nylander. The CCB is a party to litigation. It was joined as a party around the time of the last settlement agreement that was approved involving the main piece of the litigation, but not because there are allegations against the CCB, but as Chair Douglas explained, as a successor in interest to the Department of Taxation as a result of legislative change.
Okay, thank you for that clarification.
Yes, sir.
With this settlement agreement and trying to go back and forth just to make the record clear, is Rural Remedies completely out, or do they still have a claim sitting in this?
They're completely out.
Okay.
Litigation-wise and in the administrative process as it relates to the September 2018 licensing round.
Any other questions or concerns by board members they wish to raise at this? If not, if we can have a motion for acceptance of the settlement agreement.
Member Durrett, I move to approve the settlement agreement between the Cannabis Compliance Board and Rural Remedies presented to the board as agenda item 7A.
This is Member Nylander. I'd second that motion.
It's moved and seconded. Any additional discussion? Hearing none, all in favor of the proposed settlement agreement as to this item with Rural Remedies, please say aye.
Aye. Aye.
Aye. Any nays? Any abstention? Hearing none, matter carries. Thank you.
Thank you very much, and thank you as always for your professional courtesy. Appreciate it.
This takes us to item number 8, and I understand we're going to be losing Member Merritt, but we still have quorum for the record.
Thank you, Chair. So we'll move on to agenda item number 8. This is a request for consideration of approval of placement of receiver for Green Cross of America, Inc. So this is Mr. Brian Hardy's request for consideration of CCB's approval of his placement as a cannabis receiver over licensee Green Cross of America. Green Cross holds medical and adult use cultivation license numbers C035 and RC035. As the board recalls, I originally mentioned this item at our August meeting, that the CCB had received this application, but further work was needed to evaluate the situation that was developing as we received word from the licensee's attorney, Mr. James Allen, that he would be objecting to the receiver. The district court had noted in its order that the receivership order would be contingent on CCB approving Mr. Hardy as the receiver. In the interim, as you're aware, the CCB held an emergency meeting on August 26 and issued an order of summary suspension of Green Cross due to multiple violations found by investigators. That suspension is still in effect, and the licensee has been attempting to work with the CCB staff on finalizing up that plan of correction. Additionally, this past Saturday, Mr. Allen filed a motion with the court to vacate the receivership order. So Mr. Hardy is here to take questions on the request. My understanding is that Mr. Allen is also present here today to make a presentation and take questions. There may also be other interested parties present, including those who represent the licensee or owners of the licensee. Board, with your approval, we'd recommend that we hear from Mr. Hardy first, and then from any other interested parties who are here and would like to speak on this matter before the board considers the action it wishes to take. So with that, Chair, I will turn it back to you.
Mr. Hardy, good morning.
Good morning, Chair, members of the board. I'm not here to advocate for or against a receivership. That is not why I'm here. What I am here to do today is to give you my qualifications and let you know whether or not that if you decide that a receivership is appropriate, that I am a qualified individual to handle that receivership. I have provided, I believe, the executive director along with counsel copies of my resume. I can give you some background on that. I'm a licensed attorney. I am a partner currently with the law firm of Marquis Arbach Coffing. We've been around, and next year we celebrate 50 years as attorneys here at a firm in Nevada. I've been a shareholder with that firm previously, and then I left and went into I left private practice for a period of 2 years, where I went in-house and was the general counsel and vice president for a fully regulated firearms company conglomerate, at which time I dealt directly with ATF, handling all of their regulatory issues and making sure that we were in compliance with respect to import, export, we had distribution, and we had retail licenses. In doing so, I had to run the company in order to make sure that things were being done effectively. As you're well aware, the system that you utilize, Metric, has some very similarities to that of the bound book system that is utilized in firearms. And in fact, we have to report any and all transfers that come into the country, production or manufacturing, then it gets transferred. Anytime there's a transfer that happens, all those transfers have to be adequately documented all the way through the retail level. In addition to that, I've done a number of privileged licensing even before I left. That was one of the reasons that I ended up going in-house for a period of time to help this particular client of mine, was because of the regulatory work that I had done in the past. I've worked with Gaming Control Board. I've worked with a number of other regulatory agencies in order to help clients that are involved in the regulatory privilege licenses, helping them obtain and or handle compliance for regulatory matters. And in 2014, I was one of the attorneys that handled a number of the original applications with respect to the medical marijuana licenses. It was unfortunately fortunately, I guess, that I went in-house in 2016 when everything went to recreational, although I did have some input with a number of clients and continue to represent clients since coming back into private practice relative to matters before this board. I'm currently working with a number of clients and with staff on some issues that they're working through right now. And so we work to make sure that they're in compliance. We appreciate all of the opportunity. I always do to work with your staff. They've always been professional, and I look forward to being able to hopefully continue to work with them in the future on this and other matters. If there's any questions, I'd be happy to answer them.
First question, have you ever officially been a receiver?
I have not been officially a receiver. With respect to this particular matter, I was contacted because of my relationship to the industry, but still having been apart from the industry, I didn't have and as you can imagine, there are a number of attorneys that have intertwined relationships in the industry, and I'd been apart from it for a while, so I didn't have any potential conflicts. I guess that was probably one of the benefits of leaving for a while and coming back, is that I didn't have any inherent conflicts to the issue. The second being the fact that I did have experience within the industry, and that I had been working within a regulated industry before and overseeing regulated companies, understanding how they needed to work, which is different than, as you can imagine. I think we always say this about kind of attorneys and doctors, sometimes they're great in their profession, but they're not the best business guys, right? I had the opportunity to step out for a bit and actually run a business and keep this business successful in a time where, in that particular industry, during that time period from 2017 to 2019, it was a tough time in the industry. That's when you had a number of the companies in that industry file bankruptcy. We actually saw an increased growth on average year over year. We were 26 and then 28% respectively, a growth year over different types of times, different year over year benefits that we had seen in the company grow. So I've had the opportunity to work within the business, within the regulations, and see how things operate.
If I looked at your information correctly, you in the past have served, though, as an attorney for receivers. Is that correct?
I have served as an attorney for a number of receivers, and in fact for receivers, but the state has appointed. As this body may recall, 2010 was a terrible year for builders and home builders and construction companies, and as a result of many of the recession that we saw, the Department of Insurance had to take over a number of construction-based insurance carriers. Of which I became counsel for the receiver, working directly with the insurance division as the counsel for the receiver, as we collected a little over $20 million on behalf of the insurance fund and on behalf of the receivers there in order to do that. That's just one example of a receiver. I have worked with a number of receivers, including receivers that have been appointed by this board. Our firm obviously does quite a bit of receivership work. And in fact, so we've worked with both Mr. Malik as well as Mr. Leonard, who I believe have both been appointed in different receiverships for this board, both of which are highly competent, work with all of them great. They'd be probably do just as good or better job than anybody else that I know. So, but in this particular case, I was asked if I'd be willing to do this. And given the limited nature of this particular venture that they're looking to do and the timeframes and kind of what they were looking to do, what was looking to happen here, I was asked to go ahead and serve. And that's going to be the big process here is we've got to identify all the creditors. We got to identify liabilities and assets, and then we're going to have to see what we can do from there. And we need to do so in an expeditious fashion because I know that there are issues pending with respect to this licensee before this board.
And pursuant to the statute, you're aware that as if in fact you are the receiver, you have the ability to hire appropriate people to do the functions, the staff functions, and everything else. Correct?
Yeah, I have, and I apologize if I missed a little bit of that. I have hearing aids. I'm trying to use, unfortunately, with mask, it blocks my hearing aid on the top. So to the extent that I understood the question, you're asking whether I have staff and appropriate.
No, that you have the ability to hire appropriate staff in the cannabis industry or necessary to what the plan is.
I do. If it's determined that it would be appropriate to go ahead and work with a management company, whether on some type of interim basis or not, I would be able to go ahead and work with and identify a management company, subject obviously to any management agreement would be subject to the approval of this board, obviously. And then we can work on anything that we need as far as identifying buyers. If we need to retain some type of brokers in order to do that, I'm happy to work with those type of people. Fortunately, I have many of those contacts both in this industry and outside in order to try to solicit and obtain the best value, if that's determined what's necessary for this license.
I have some things that I wish to bring out, but or any other board member wish to inquire at this time?
Mr. Chairman, this is Member Nylander. Mr. Hardy, though it appears the legislation that was enacted during the last legislative session requires one to have prior experience as a receiver. So how do we interpret that in your view?
Well, I think that the problem with that is that you're going to eventually limit yourself out of receivers, right? And so one of the things that I think that you can see here is that we have served as counsel, and I have worked directly with a number of different receivers. And so it's not that I have the lack of experience that would be necessary in order to handle those type of issues. I do have experience working directly with receivers, and so to the extent that there's a requirement that there be some type of prior experience dealing with receivers, I would have that experience. But as a receiver, you're correct. I am not and have not been a receiver. But the only way to gain that experience is through serving, right?
Well, no, and I understand it's sort of a chicken and egg thing. You know, how do you ever, right? And I don't know, you know, I do recall the legislature was simply trying to set up rules in place that could govern these future receiverships. And, you know, because it was something that had come up for us as a board, you know, and looking at other industries that have provisions. For example, gaming is one, and it does require prior experience, but I'm not sure why they worded it specifically to say that you had to have exact prior experience. But I guess I'm trying to understand sort of the interpretation. So if you've served as counsel to a bunch of receivers and you appear to be qualified in my view, and you know, certainly this situation, there needs to be a receiver in my view in these circumstances. But so I guess if your argument is that if you were counsel to a receiver, that's the equivalent of effectively meeting the qualification of having previously been a receiver.
Correct. That would be in the fact that I've had significant experience representing and working directly for receivers, including receivers that have been appointed by the state. For example, over both Builders Insurance Company and Nevada Contractors Insurance Company that went under, I've been able to serve in those capacities, work directly with those receivers, advising those receivers and helping them out such that I've gained that similar or substantially similar experiences.
Understood. And I think that the spirit of, you know, being a receiver, there are certain fundamental things that one must do that don't really distinguish among industries. They're all the same principles of, you know, preserving assets, you know, finding out who the creditors are. All those things don't matter if it's cannabis or not. It could be anything. So no, that's all I had, Mr. Chairman. Thank you.
Thank you. Mr. Hardy, I'm going to give you a chance to respond because we have an opposition to this request on behalf of the board, though there are some concerns having read some of the prior action and the order of the court. I'm a little concerned as it relates to the authority of the board or the prior orders of this board reference this licensee. And I understand that the role of the receiver is different from quote, a licensee, but yet they do merge together. And there are some concerns with issues presented by the court in the broadly stated original order. But having said that, we'd like to hear at this point from those opposed. And as I said, we'll give you an opportunity to respond.
Thank you.
Oh, Chairman, can I ask a quick question before Mr. Hardy sits down? Well, I had the same question as Member Nylander. The statute just seems so specific, so it's hard to grapple with that. But I think I would. So as much as you can give us a way to apply this to you, or to have it not applied to you, the better. But I did have one question. So the adequate finances, I don't doubt that you have the adequate finances, but can you tell us a little bit about who would be financing it? Would it be the firm? Would it be
So
the client?
if you look at the way the fee agreement is worked on this particular deal, is that obviously I don't receive any payment on this until we've been able to start either generating revenue or consummate a transaction in which to generate revenue. I have not had, because, and again, I'm not the receiver here, so I have not stepped into any of this organization, and I'm not going to until approved by this board, because I don't believe that would be an appropriate measure to start getting into things, particularly within a regulated industry, until you've been approved to do so. And so I don't have a direct information on what assets they do have, what liabilities they have. I have some information that I've been provided by some of the attorneys in this matter, but beyond that, I don't have any of that information. I have been able, and there's been attempts and communications to try to reach out to some of the attorneys in this matter, and those that have responded and provided me information give me some insight. But it appears that there are, from what I can tell, limited assets as a part of the license holder. And if that's true, then we're going to have to work through that, and we'll be able to do so on a contingent basis until we can go ahead and identify where we can go ahead and put forward the assets necessary in order to fund operations. And if it, like I said, I indicated previously, if it means through an interim management agreement that can be approved here, and that can help provide some of the funding necessary in order to get operational, if that's what's appropriate in order to get the license to maximize its value or sale, or if we can get it out and get the debts paid off as a result of that, that would be appropriate. But that's, I'm going to have to get further into it in order to really identify where those come from. But as at the beginning of this, I'm on a contingency, and I understand that.
Yeah, I would think, and maybe it's just, I don't know enough about receivership, but I would think you're going to need to print money, because especially with cannabis, it's expensive, it's cash intensive. So the money is going to need to come from somewhere, and you're going to need to know where that's coming from before you start.
Correct. And we would have to identify how much is going to be needed, or if any at all. Again, that comes down to the assets that are currently available versus those liabilities. And so if I can identify the assets first, and then I can come back and find out if the loan's going to be appropriate, that we can then, whether it's on a short-term lender and we can get that approved, or whatever we need to do, we can go ahead and take care of that on an as-needed basis. One of the requirements, as you know, of a receivership is to provide monthly status reports or periodic status reports. And in the court in this particular matter, I indicated that I'd file a monthly status report. I'd be more than happy as a part of that, and I would assume that it would be preferred by the board to be able to make sure that it received a copy of that monthly status report, so it can know kind of what's going on with this licensee and kind of the processes that we're following. If appointed, that would be something I'd be more than happy to accommodate.
Anyone else? If we can hear from speaker.
Thank you.
Mr. Chair, I believe we have Mr. James Allen here, who is the counsel for the licensee. You'd like to hear from him first?
Good morning, Chairman.
Good morning.
Members. My name is James Allen. I'm a licensed Nevada attorney, license number 4506. I come before you. I'm hired by Musa Konam, who's a majority shareholder of Green Cross of America. I'm before you on behalf of Green Cross of America, Inc. To advise and fill you in on the facts leading to this. First of all, we first learned of the application for appointment of receiver through the Attorney General's office and the Cannabis Compliance Board, not through service by the court. I am the designated person for receiving any correspondence. I'm the point of contact for the Cannabis Compliance Board. My client is the president and CEO of Green Cross of America. He was assumed that position in July of 2020 after some litigation with Green Cross of America. And we have an agent of service process at the premises, none of whom were served with the process wherein the court said you can appoint Mr. Hardy as a receiver of the Cannabis Compliance. Proves it, which is why I brought our action with the court to set aside that, because one of the fundamental concepts of fair litigation is due process, notice and an opportunity to be heard. We're not provided notice or an opportunity to be heard before the court. We were put before the board on a court order that we had not received, had not been served, and were unaware of until we were notified. That said, we filed our opposition. It is our opposition, I should say, our motion to vacate the appointment of receiver court. That is set for hearing December 2nd in front of Judge Denton, who issued the order. There's another litigation, I believe, started by, another litigation seeking to enforce the terms of the court order, but that is not before us today. The motion, the application for appointment of receiver was brought by Michael Sassano through, I should say, by Red Dot, through by Michael Sassano's company, Red Dot. Michael Sassano obtained a judgment against Green Cross of America on a litigation he filed starting in 2017 for monies advanced to Green Cross of America's previous management group, obtained a judgment in the amount of $280,000, was unable to execute it on the other named defendants, being Philip Restifo, who was at that time the president and CEO of Green Cross of America, or the other entities which Mr. Restifo was an owner or operator of. Mr. Philip Restifo has since died. Green Cross of America is the only left bankrupt, shall we say, entity. Green Cross America has other creditors. It has the landlord of this facility, and it has Musa Kodam, who brought his own action to basically receive the balance of the shares from Green Cross America that Philip Restifo had died and attempted to pass to others. That said, Musa Kodam is the largest unsecured creditor of Green Cross America. As Mr. Sassano pointed out in his declaration, there are other creditors. Mr. Sassano is certainly not the largest. So our issues with the court, with the orders of the court, we'll take up with the court, and we believe that the court will vacate the order appointing a receiver over Green Cross of America. But that said, we're here today to see if this individual would qualify as a receiver if the court didn't set it aside. I submit he would not. Mr. Hardy has never acted as a receiver. That is the requirement for a receivership before this board. And there's reasons for that. You want experienced people that are able to comply with the court's orders to gather together the assets, manage them, and dispose of them in a proper manner. I mean, I can tell you, I've also acted as an attorney for receivers on several occasions. That's not being a receiver. Receiver is the arm of the court. Is not the arm of the creditor, which concerns me because in this instance, Mr. Hardy is saying, well, I am going to set up a contingent fee agreement because there's no money there. Well, Your Honor, I'm sorry, board members, that is not an appropriate way to run a receivership. Anyway, I submitted to the board, and I apologize that you probably haven't had the time to completely review all the documents submitted, but the application for receivership to the court didn't even mention Mr. Hardy. All of the documentation relative to the qualifications of the receiver were for an unrelated third party that 2 years ago, Mr. Sassano had attempted to set up as a receiver, and who I was able to make contact with, discuss with, and lay out a course of action if he were to become a receiver, but he was never retained by Mr. Sassano. That said, we oppose the appointment of receiver based upon the fact that we were never provided any notice of the application to appoint the receiver with the court, and we only obtained the order for appointment of receivership through our investigations and our requests from the Cannabis Compliance Board and the Attorney General's office. As I said, lack of notice is the basic precept under which we are able to act. You're able to act, I'm able to act. Um, I would submit to the board that this is not an appropriate application for a preliminary receiver, and this is not an appropriate receiver for performance of the duties of receivership in this instance. We're here on a lack of notice to the person or the entity upon whom the receivership is to be imposed upon. And again, that is the basis of our application to the court to vacate the receivership. I provided you our moving papers to the court. This business, Green Cross America, does have a history of issues that initially were created by your predecessor, the Department of Taxation. Basically, our license was transferred prematurely, and it took literally, well, a year to get it back. Shortly after we got the license back, we had wind damage to the premises that we lease. And that wind damage came at an inopportune time. It was a covered loss, but it took months and months to get the carrier out there and to get the repairs started. And you're all aware of the slowdowns we've had as a result of the pandemic. I don't have to tell you what the situation. And during that repair period, we ran into other problems that we're dealing with in compliance with staff. However, the bottom line is, I have never heard of, and I don't believe that there's an instance where it would work in this instance, a receiver being elected by a minority creditor and put on some sort of a contingent fee, where that minority creditor is going to be able to run the company with someone that has never run a company as a receiver, and particularly a company as sensitive as one licensed by this board. With that, I'm open to questions.
I am concerned when I saw your papers, I saw a response to the papers filed from the court saying this matter over December. In light of this matter being for consideration by this board today. If you were aware, did you make the court aware of the timing of these events? And a matter of significance was before this body today, since we now have a December 2nd date for the court to.
I did, Chairman. I asked for a hearing to vacate the receivership on shortened time. I don't even get to request a specific date. The court takes it as the court's availability allows. I would advise you, but both the judgment in favor of Mr. Sassano or red dot, as it is now. Originally, it was F&E. It's same ownership. That was in front of Judge Denton. There's another matter that was brought on, I think, on Mr. Hardy's behalf. I've not been served with that yet either. But that is to force this board to accept him as the receiver. That's with a different judge. I think that should be moved over to Judge Denton. I've had some discussions with the Attorney General's staff to that regard. I think that's probably something that they're going to address. Know the staff of the Attorney General's office was not. They had the same situation I did. They did not get service timely to allow this matter to come before the board when it was originally set for. But the problem is, from my standpoint, I can only react to the stuff that I'm aware of, that I'm served with. And I got this information filed by this creditor, or on behalf of this creditor, I should say, by having to request it from both the Attorney General and the CCB. I mean, you were kind enough to provide it, but they didn't serve it upon me. And, you know, that's not Mr. Hardy's fault. You know, he's the designated person act as receiver, but that certainly would fly in the face of a claim that there's an emergency.
Questions of Mr. Allen by other members of the
Member Durrett, for the record, what's the plan if Mr. Hardy isn't appointed as a receiver? What's Green Cross's plan going forward since they're not operational?
We've had a structural engineer in because the post damage repairs that the insurance company advanced the majority of the funds to do still require the approval from a structural engineer. The structural engineer has been in, suggested some modifications to the repairs that were done by the contractor. We're negotiating to accomplish that. The other thing that we needed to accomplish was the creation of the, I shouldn't say the creation, the reinstallation of the security system that the prior tenant took with them. And we have a bid for that. So I think those are the two things. We've submitted our plan of correction to the CCB staff. We got comments back. We made corrections to that. I think we're planning on being in a position to operate within 60 days. If all goes the way it's supposed to be. It does require a rather significant investment, as you pointed out. Dr. Conum has personally invested from his own retirement account almost $1.5 million towards this project. So the creditor is seeking to put a receiver in. His judgment was $280,000. It's almost like letting the tail wag the dog.
Mr. Allen, still wagging the dog. Says about the operation or non-operation with costs closed. But there's also issues as to Nye County. Sorry, my mic was not on, so I'll repeat myself. We are concerned not only with our concerns of the operation during the alleged non-operation period of Green Cross before us that we're just opening up, but also the report backs we got with concerns in Nye County of business licenses allegedly in default and expired.
If I may address that.
Yes, please.
And that is a legitimate concern. The business license, the County of Nye, as a result of the actions by the prior body, the actions of the Nevada Department of Taxation, terminated the special use permit issued to the premises. The special use permit we applied for to get back in order to, and the application was approved. We still have to have the balance of repair work done. The balance of repair work being the structural. We have to have the approval from the structural engineer to get the sign off from the county, and we have to have the Cannabis compliance license not only in place, but we have to have the cameras up. Those are the two things that they're concerned with: is the structural repair having been accomplished. The Sheriff's Department, of course, wants to see the cameras up and in place. So that the action of the county was as a result of the prior action by the state of Nevada, saying, okay, your license is, well, we had to go through the things that we had to go through in order to get the license back up and operating, following the exhales having had possession of our license.
Mr. Allen, let me ask you, I guess, my final question. Because I have to ask it this way, what is the harm for this board to take the action that's been requested, approval of Mr. Hardy to go forward and get his necessary card so he can report back to the court? What is the harm of us doing that for the period between now and when the court is going to hear your opposition?
I don't know Mr. Hardy from Adam, but I do know that from his own admission that he has never been a receiver. That is a requirement. I did take the time to, the last time Mr. Cesano made a shot at putting a receiver, and I spoke with the receiver, contacted him and said, okay, fine, I see that you've acted as a receiver in the past. You're aware of everything that must be done. What are we going to do in this situation? Had a long discussion with them. Okay, here's how we would accomplish it, et cetera, et cetera, et cetera. Mr. Hardy's never been a receiver. He doesn't meet the qualification of this board to act as a receiver.
I'm not speaking specifically as Mr. Hardy. I'm speaking as to this process. You have a district court judge who is theoretically going to supervise this activity per the court documents that are on file. So is there harm that we should be concerned to the licensee, licensee properties?
To the extent that we were not given the opportunity to respond to the court, yes, because that is the basic, that's the basis of any due process. We have to be given the opportunity to be heard in front of that judge. The only way we're getting heard in front of that judge is because we're bringing a motion before that judge because we were never served with their application, never even provided notice of their application. You know, I guess the quick question is, I don't know how much harm could come from it. I just don't know. I wasn't party to the discussions between Mr. Hardy and Mr. Cesano as to how he was going to get paid or any of those things. Don't know. All I know is that we've had an inability to work with that particular creditor, and his approach to attempting to resolve the problems has been to attempt to litigate and force Green Cross of America to concede to his demands to be paid his $280 when we have a lot of other individuals that also have to have an investment in this asset.
Questions by Mr. Allen, by other board members before he sits down?
Thank you, Chairman. Thank you, board members.
Thank you.
I'm available for further questions if you need.
Mr. Hardy, if you wish to say anything additional.
A couple of things I want to make sure and that we have clarification on is that my agreement is not strictly contingency. As you've seen, it's a hybrid. And what I mean by that is that I am paid, I'm a receiver. And so I will be accruing fees and costs along the way. But if it's necessary, and what was negotiated and what the court kind of clued in on was the fact that they wanted to say if the asset has to be sold because they're unaware of what the assets might be, that they wanted to make sure that we achieved the highest value of sale on those assets. It wasn't something that was done at bargain basement rates. And so what they did is they put a contingency based upon a sale, a percentage of the sale over a certain dollar amount to make sure that all of the identifiable creditors were paid, one, and that hopefully there would be some left over. And that's always the goal with any receivership, to make sure that there's some left over to pay back the existing holders. The second thing that I want to point out is that Mr. Allen has not reached out to me, and we've reached out together, tried to send emails. We are, as a receiver, I look forward to hopefully being able to sit down with the licensee and Mr. Allen, if appointed, to be able to sit down and work through some of these things, and hopefully we can identify what we need to do to make this a successful venture. so that it can come out of receivership. I mean, that's obviously the goal. And if it can't come out of receivership, then to go ahead and liquidate the assets if necessary, and then to make sure that all of the creditors and Mr. Allen's clients receive back their investment if possible, or as much as possible. That's the goal of every receivership, and that's what we're looking to do here today. Finally, with respect to Nye County, I have been able to be in contact with Nye County commissioners. In fact, during the most recent hearing, the Nye County commissioners decided to watch what was happening at this proceeding, as well as to observe what's going on at the court proceeding before taking any action relative to the SUPs there. And so they've went ahead and obeyed that matter for a period of time to just kind of see what's going on. Everybody's optimistic because these rural counties have very few licenses, as you're well aware. And diversity amongst the licensees is an important thing for this board to do, making sure that the counties, and especially the rural counties where there are very few licenses, have the opportunity to continue to maintain those licenses. And they'd like to be able to see those licenses maintained, but they want to see them operated effectively and operated in such a way that they can be a profit center and an opportunity for their residents. And that's what Nye County is looking to do, at least based upon my discussions with the commissioners there. So to that extent, those are some of the issues that I think were addressed. The other, with respect to notice and everything else, I'm not the attorney that was involved in that particular matter. I did receive yesterday a copy of the application to vacate my appointment. Again, I'm not here to advocate whether a receiver is or is not appropriate. I think that's this decision for the district court judge. The attorney, Jason Wiley, who's for the other side, can speak to whatever the notice is or whatever the requirements are on that matter. I do notice that it was filed on a order shortening time, but there's a number of information and deficiencies in the motion that have made it so that I don't see that the court has set it on an order shortening time. Generally, that requires affidavits and other things like that, and they're just simply not here. And so there's some defective issues, I think, with the application. I'm sure it'll be heard in due course, but I don't think it's going to be heard at an order shortening time. The other thing that I would note is that the notice of entry of order in this matter was done on 8/17 of 2021. We tried to work, and I want to compliment the executive director. He was immediately on the phone as soon as this matter was, he realized that there was a receiver potentially appointed, reached out. We talked about trying to maybe get it on the sooner agenda in order to make sure that things were taken care of in a timely manner. And we wanted to make sure that once Mr. Allen had been notified, that we gave him the time once he realized that there hadn't been time. And so that's why it's been set off till today, is to give everybody the opportunity to be heard. But since that 8/17/21 date, it took them almost 2.5 months to finally file an application to vacate my receivership. If they wanted to truly vacate it, I guess they could have done it earlier. It's those kind of delays that obviously concern me. Should I be appointed as a receiver, I need to go in and make sure that we're following through, whether it be with delivering to the court on time, whether it be making sure to work directly with the CCB and provide timely responses, those things that are important. Thank you. Any other questions?
Any questions by board members? Mr. Hardy, thank you.
Thank you, Chair.
Comments, concerns, discussions at this point, and whether or not the board, we have someone else who possibly wishes to speak.
Briefly, Mr. Chairman, as Mr. Hardy alluded to, my name is Jason Wiley. I just want to address the due process matter. This is a litigation that was commenced in 2016. The application was filed as an ongoing document as part of that litigation. We served all parties through the court's electronic filing service. If you notice in Mr. Allen's moving paper that was filed on Saturday, he doesn't call himself the attorney of record for Green Cross. He calls himself the quote unquote the point of contact. He's never made a notice of appearance that would allow for him to acquire the documents that are filed pursuant to the electronic filing system. So based upon that issue, we complied with all the requirements of NRCP 5 regarding service to the entity and complied wholeheartedly. As Mr. Hardy alluded to, our order appointing Mr. Hardy that was reviewed by Judge Denton and entered by Judge Denton was done so in mid-August. This matter was initially put on calendar on the late August agenda. At that time, the board reached out to Mr. Allen, who indicated that he did want to oppose. As Mr. Hardy alluded to, it's been over 2 months since then. He's never provided any correspondence or opposition to the board. Instead, he filed a document which is rogue in nature with the district court 2 or 3 days prior to the hearing before the board. And the issue with that is twofold. As indicated by Chairman Douglas, there are certain deficiencies on why this matter is not going to be heard by the court on an order shortening time. Most of all, the fact that the required declaration or affidavit from counsel showing or evidencing why the matter should be heard on shortened time is not included. Mr. Allen still has not made an appearance as counsel of record in the litigation either. Based upon the timeline of events in which Mr. Allen was given notice in late August of this year, he could have filed a motion for reconsideration of the court's order. He could have undertaken other action. He simply didn't do so. Never reached out to my office. You heard Mr. Hardy state that he never reached out to Mr. Hardy to discuss this matter. And now we get a rogue filing a couple days prior to today's proceedings, which I fully believe will be addressed by the court, but unfortunately, because of the deficient nature, we're not going to get a ruling from Judge Denton until early December. Based upon that, the fact that the Judge Denton did review the application, did sign off on the order, the appointment of the receiver in order to effectuate the judgment is proper pursuant to statute, and we would respectfully request that the board approve Mr. Hardy to allow for this judgment, which, oh, by the way, my client obtained in July of 2017, so that that judgment can be satisfied in full. And if you have any questions, I'd be happy to address. If not, I'll rest.
Mr. Wiley, you crafted an order that was signed by Judge Denton. I'm really concerned with the language you have in paragraphs 19 and 20. Just in terms of the Department of Tax, we may not cancel any license, permit, or governmental approval previously issued. Well, presently they're sitting without a license because it has not been renewed, and some others. But then 20, basically that you can just force us to give them another license without going through anything in terms of the alleged violations that occurred. That language, from our standpoint as a cannabis board, is just downright overreaching and offensive. And we weren't a party. We got no notice. So I'm just stating that for the record, that you understand that we don't particularly like, when we're regulating a privileged industry, to be told that we just grant a license and look sideways and not go through the appropriate procedure for the licensee and the other players to solve or resolve their differences. But that's an aside to what is before us today.
Understood.
I understand you complying with the rules of civil procedure as to service and whatnot. We appreciate these comments for the record.
Thank you, and duly noted on the concerns of the board, and we will address those as well.
Before you sit down, any questions by members of the board? Mr. Wiley. There's no questions. Thank you, sir.
Thank you for your time today.
Now coming back to the board itself, as to the matter before, as to the request for a placement of approval, and we note for the record, the district court has indicated that they wish to appoint Mr. Hardy as a receiver. However, it is up to this board to indicate. Yes, sir.
I'm an owner investor of Green Cross of America.
Excuse me?
I'm an owner and an investor of Green Cross.
Excuse me, please. I'm sorry to interrupt. This is the reporter, and I cannot hear if somebody is speaking right now.
The individual is in the audience at this point, so come forward and identify yourself for the record.
Good morning, Chair Douglas. My name is Stephen Restifo. I'm an owner, investor, not involved in the daily operations of Green Cross of America. I do want to say, though, that Jim Allen was correct, and even though Jim Allen does not represent us, in that we did not get in any notice or service of this till this day. We received this information from another shareholder, and while we're here today, We were notice of hearing. So we feel that there's a conflict associated with Mr. Hardy being appointed as the receiver due to the fact that Red Dot, one of the owners of that, Michael Sassano, that does go back from the original Green Cross of America and worked with my father, Philip Restifo, deceased Philip Restifo, and is looking to go ahead and put this receiver in place. What I got out of Mr. Hardy and what I read is that he was asked to do this in a limited fashion. He is looking to identify buyers and has contacts. We feel that, you know, we are investors and owners, and that we would like to be able to have a say in who the receiver could be or should be, so that we don't feel that there's a conflict, that it's in the interest of one creditor who's been pursuing to get this for many years. And so
I'm
that's it.
Sharman Thomas. I'm also an owner investor. I live and reside in Memphis, Tennessee, so we don't have any access to day-to-day operations. I'd like to say we're not opposed to a receivership. We're just opposed to this receivership. We like time to vet and just kind of see what that all entails. We were not aware of the damage and hailstorms to the building and all of the violations that were found during that time. So again, I like to state for the record, we're not opposed to a receivership. We're just opposed to how this receivership came about. We did not contact Mr. Hardy, and we were not aware of him. We've never even heard of him. So that is why we're here today.
From a standpoint, is Mr. Allen, who is coming before us as representing the interest of Green Cross, is he representing your interest, or do you?
No, he's not, Chairman.
It's not.
He, Mr. Allen represents one of the other shareholders.
Musa Colony.
Yeah, he's the larger shareholder out of the group. 3 of the other shareholders have died. So my father passed away, Guy Mazzola, who was also an officer, and Peter Necco. They all passed away. But we weren't notified of a lot of things that have been happening under Musa being the CEO
Right.
and president, who is one of the other shareholders who Jim Allen does represent.
Yeah, we were not aware that he's now the CEO. We were not apprised of any of the damage. We were told that the insurance company, after we were made note of the damage storm, maybe 3 weeks ago, that the insurance company would take care of those. So we would just like an opportunity to meet amongst the owner investors to see where we are, to see if we can get together and move forward and come to an agreement as to how and who should be the receivership, if that's even a possibility. At this
We just
point.
feel that there's an extreme conflict associated with this receiver being appointed in the lawsuit from Red Dot, Mike Sassano, who inherited the judgment from F&E, who actually lent money to my father to put into Green Cross of America. And then after he passed, they tried to sue him while he was passing, and they did. And they got judgment. So that's fine. I respect the court for that. But the pursuit of trying to get this license out from under Green Cross of America, we feel that it's a conflict with Mr. Hardy being appointed as receiver due to who's of trying to get him in there.
Your objection to Mr. Hardy and the receiver appointment with the court is outside of our
I
domain.
understand, Chairman.
So the real question we have for you to help us look at this whole picture is whether or not you intend to hire counsel to weigh in on this matter with the court.
Well, we didn't know we needed counsel until we basically started to see what was going on here in mid-September and early October. So we are in the process of speaking to counsel locally, but we have not hired any counsel at this point.
And I can appreciate your position, but having said that, other members of the board wish to ask either one of the individuals before us at this time any questions?
Thank you, Chair Douglas
Thank you.
and members.
Since I was premature last time, do we have anyone else who wishes to make any comment? Hearing none. Now to the board members as to their thoughts or their wish to make a motion.
Mr. Chairman, this is Member Nylander. I kind of where I'm at right now is I feel like this is not ripe for our consideration at this point. The state is protected because this license has been suspended. And I would ask the Attorney General, I don't think there were any limitations on that suspension, but there is effectively no cannabis business occurring right now. So I don't know, the state is not at risk if we don't do anything. So my thinking right now is that it's not ripe for consideration. There's so many moving parts among these parties. And I respect that the district judge did appoint the receiver, but there now appears to be other facts that were not present when the judge considered that, and he's being asked to reconsider it again. So I just feel like, at least from my perspective, the state is not at risk, and these parties need to sort of get together and figure this thing out. I would support deferring this for the time being, but I also would like to get clarification from the Attorney General's office on the suspension.
Member Nylander, the facility is still summarily suspended. That suspension still is in place. Any cannabis that was on site was, to my understanding, destroyed. They cannot go operational again until they have sorted everything out and have staff approval to go operational.
Okay, thank you for that. That was what I was thinking. And so I don't see any harm to the state if we don't take action on this, but I'm obviously willing to discuss it further with the other members and you, Mr. Chairman.
And Mr. Rath, just to follow up on that question, if we took no action this date, that would not prohibit the court's receiver, as he is present, from doing whatever due diligence he needs to do to see what the status is of that business. Is that correct?
Well, Chair,
even though he could effectuate going forward with our body.
The court order is contingent on your approval of this receiver. And my understanding of the court order, which I know you have all read, would also, preclude any disciplinary action or any other action by CCB if this receiver is approved, which I believe you've also identified as problematic. Does that answer your question?
If that's the best answer you can give me, I guess so.
I agree with Member Nylander that I don't think we have enough information. For me, we really need to know at the minimum how it's going to be financed. And I don't think that, again, it could be a lack of experience with receiverships, but saying, well, we need to find out if they have the money to support this is sufficient. I think you have to have a backup. And if in case they don't have the assets to pay for it, you have to come with the financing. So we just need to know where those funds are coming from.
Dr. Young, do you have anything you wish to put on the record for us today, or are you just listening?
Listen, it appears to me that there's a lot of things that haven't been answered regarding this issue. And it sounds somewhat that the due process has not been completed and that they're going to have another meeting before the court in, I guess, December, that is.
It's December 2nd for the,
Okay, that's what I thought. Yeah, I think there's too many unanswered questions for the board to move on this at this time. Essentially, I guess I'm in support of Member Nylander and his statements.
being the comments of the board, I will be bold enough to make a motion to hold this matter till our December meeting, which would be after the December 2nd court date.
I would second that motion, Mr. Chairman.
In hopes that the court date will provide enough information for us to go forward at our next date with an appropriate response to the request. Having said that, anyone else wish to weigh in before I call for, we did have a second? Before I call for the vote. Anyone else wish to weigh in, board members? Being the case, we have a motion for approval of the motion that's been offered this date. All in favor, please say aye.
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 Aye. Any opposed? Any abstentions? This motion is being held, the matter is being held to our December meeting for additional information and for consideration for the cannabis approval of Mr. Hardy.
Thank you for your time today, Chair.
Thank you, Mr. Hardy.
We'll see you in December.
And I would hope that the parties can meet to see if they can resolve this issue. Next on our agenda is item number 9, consideration of proposed amendments and or additions to Nevada cannabis compliance regulations.
Our Chair and Deputy Director Michael Miles will be presenting this item. I just would like to point out that this has gone through the normal process of an informal comment period and then a formal workshop that all board members were present at. And all of the changes, both after the informal and the official, are notated in this item. So with that, Deputy Director Miles, when you're ready, you can go ahead.
Good morning, Chair and members of the board. The record, my name is Michael Miles. I'm the Deputy Director of the Cannabis Compliance Board. I'll be going over agenda item number 9. I'll be summarizing the amendment timeline and proposed amendments and or additions to the Nevada Cannabis Compliance Regulations. On August 13th, 2021, the CCB sent a notice for input of the proposed amendments to NCCR 1, 6, 7, and 12 and accepted public input until 5 p.m. on August 22nd, 2021. On September 3rd, 2021, the CCB posted a regulatory workshop notice and agenda for formal public workshop in person in Las Vegas or in Carson City to be held on September 14th, 2021. CCB staff reviewed and implemented numerous recommendations that were received during the informal public comment period and the formal public workshop. A final copy of the proposed regs has been presented to the board. I'll give a summary of the amendments that have been made since the public workshop was held on September 14th, 2021. Reg 1, Regulation 1.069, and all of the Reg 5 suggested amendments have been deleted. Regulations regarding cannabis receivers are undergoing further revisions based on comment from the public and board members. Revised receiver regulations will be posted later and considered at a later workshop. As to Regulation 7, Section 7.060, the requirement to ensure no minors under the age of 21 years of age are to be in the vehicle during curbside pickup was deleted. In Regulation 12, Section 12.015, language was added to say packaging changes in this section became effective on May 1, 2022. This gives licenses time to work through their existing packaging. 12 point in Reg 12.015 Section G. This language was added. A list of all ingredients and all major food allergens is identified in 21 USC Section 343. This aligns with the FDA Food Code labeling requirements. And Reg 12.015 Section H, in more added language, it was added a notice that the actual amount of THC may be within 15% of the stated amount for the edible cannabis product. This was added here as a package requirement because it was removed from the label requirements for edible products. In Regulation 12.020, the name Nevada Universal Cannabis Symbol was added. This helps clarify the required symbol is the Nevada Universal Cannabis Symbol. Previous language just referred to it as the symbol. 12.035, Section 1, staff reviewed feedback received during the formal workshop and added the language, if not already on the container or package, which helps identify or helps clarify the label requirements for production facilities. In Regulation 12.045, Section 1, staff received feedback received during the formal workshop and added the language, if not already on the container or package, which helps clarify the label requirements for cannabis sales facilities. In Section 12.070, language is added to say subsection 3 of this section becomes effective May 1, 2022. This gives licenses time to update their existing packaging. Does any member of the board have any questions as to NCCR 167 or 12 or any of the other changes? We have staff available for any questions.
Before we get any additional questions from the board, if they have any, what I would propose we do is go through these as the A, B, C, D, E items separately to see if we have anyone in the audience which wishes to speak as to any of these items, and then make a decision. A, whether the board has any questions, additional questions of staff, and whether or not we can take these as a total block or whether or not we need to carve out anything.
You want me to handle that, Chair?
We could, yes.
Is there any public comment on the change to NCCR 1.051, which is the definition of advertising and advertise? About to NCCR 1.081, the definition of derived. And how about the definition, or the NCCR 1.083, edible cannabis product defined?
If you could state your name for the record.
Good morning, Chairman, Board. Amanda Connor with the law firm of Connor & Connor PLLC. I just wanted to point out with the definition 1.083 edible cannabis product with the proposed amendment to add medical cannabis product to that, the implication would be that under regulation 12.010D, which limits packaging limitations, no further would medical edible cannabis products be allowed to exceed 100 milligrams of THC, which is currently in practice for medical patients who need higher dosage. This change in definition would effectively eliminate that permissive medical higher dosage. Thank you.
Thank you. Anyone else as to our section A?
Any board members have any questions on section A?
Yeah, you've heard the concern as to how this affects that alleged conflict with NCCR 12 provisions for medical. Is that something that was considered, or is that a new issue?
This is a brand new issue. We did not hear about this in the informal or the public workshop. So I would like to ask Chief Gilbert if he has any comments on this comment.
Thank you, Steve Gilbert, for the record. Deputy Director Miles, I agree with you. We have not explored this, and we would have to go back and look at this and see if a correction would have to be made.
Okay. We have that. We'll come back to this after we've heard whatever comments we're going to get. Thank you. If we can proceed to the B items.
Sure. These are changes to NCCR 6.025, which is about the time and effort. Also NCCR 6.060, which is operation in accordance with plans and specifications. Does the public have is there any public comment on changes to Regulation 6 or agenda item 9B? Seeing no comment, does the board have any questions as to subsection 9B?
No questions being raised at this time. Can we go to C, Regulation 7?
Going to C. C is, again, Regulation 7, NCCR 7.060. This actually codifies in regulation our successful curbside pickup operations at cannabis sales facilities. Is there any public comments as to agenda item 9, section C? Seeing no public comment, does the board have any comments on agenda item 9, subsection C?
No apparent questions. And if we can move to item D, Regulation 11, independent testing facilities.
It's to agenda item 9D. This is NCCR 11.050 concerning required quality assurance tests and submission of wet cannabis for testing. I believe all this does was remove terpenes from the testing criteria. Do we have any public comment on agenda item 9D? Seeing no public comments, do you have any questions from the board about agenda item 9, section D?
Let's go to E.
As to agenda item 9E, this is Regulation 12, packaging and labeling of cannabis products. Multiple changes to NCCRs in here. NCCR 12.015, the requirements for edible cannabis products. NCCR 12.020, the stamp or mold required for edible cannabis products. NCCR 12.030, cannabis cultivation facilities, the required labeling for those facilities. NCCR 12.035, required labeling for cannabis production facilities. NCCR 12.040, required labeling of usable cannabis and cannabis sales facilities. NCCR 12.045, again, required labeling of cannabis products and cannabis sales facilities. NCCR 12.050, required disclosures and warnings from cannabis sales facilities. And NCCR 12.070, advertising of cannabis. Do we have any public comments on agenda item 9E regarding Regulation 12, packaging and labeling of cannabis products?
Hearing none, questions by any members of the board? There are no additional questions. This is now on for our approval of the proposed changes to the regulations. I would make a motion for approval of item A, holding sub 3 as the NCCR 1.083 edible cannabis products, so that staff can look at the concern that was raised this date. I would, within that motion, additionally add approval as to Regulation C and its subparts 1 and 2, 6.025 and 6.060. Item C, Regulation 7 as to NCCR 7060. Regulation D, item number D, Regulation 11, which encompasses NCCR 11.050. And item E, Regulation 12, which encompasses 1 NCCR 12.015, number 2 NCCR 12.020, number 3 NCCR 12.030, number 4 NCCR 12.035, number 5 NCCR 12.040, number 6, sub-6, NCCR 12.045, number 7, NCCR 12.050, and number 8, NCCR 12.070. That would be my motion. As I said, it's holding the one subset of as is 1.083.
Mr. Chairman, I would second the motion.
We have a motion, we have a second. Do we have any additional discussion by any board member of this proposal? Hearing none, all in favor of adoption of these regulations, please say aye.
Aye. Aye.
Aye. Any opposed? Any abstentions? Motion carries as so stated. Moves us now to number 10, consideration for approval to extend February 5, 2022 final inspection.
Thank you, Chair. So we've got 5 requests for extension before the board today. Chief Steve Gilbert, attending from Carson City, will present these items, and I believe we have representatives for each of the licensees here as well to make short presentations. So Chief Gilbert, when you are ready, please proceed.
Thank you. Good morning, Chair, members of the board. Steve Gilbert, Chief of Administration for the record. I'm here today to present agenda item number 10, which consists of petitions submitted by Essence Henderson LLC, Essence Tropicana LLC, Pure Tonic Concentrates LLC, Green Therapeutics LLC, and HH Sub 1 LLC to extend the February 5th, 2022 deadline to receive a final inspection by the CCB. The 5 licenses listed submitted petitions to the CCB to extend their deadline to receive their final inspections. The documentation that was submitted related to delays are primarily due to county moratoriums and/or delays in construction. I'll be going through each licensee request separately. Agenda item 10A is for Essence Henderson LLC. Essence Henderson was issued a conditional use retail store license, RD 348, on December 5th, 2018, within the Carson City jurisdiction. On October 12th, 2020, the Cannabis Compliance Board issued a notice to Essence Henderson that its retail store facility must be inspected and approved for final licensure by the CCB and complete appropriate local government requirements no later than February 5th, 2022, or the license will expire. On August 9th, 2021, Essence Henderson, through its legal counsel, submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline. Specifically, Essence Henderson requested an extension for 14 months after Carson City lifts its moratorium. In its request, management reported Carson City jurisdiction currently has a moratorium on new adult use cannabis establishments. The CCB agent contacted the planning manager at the Carson City jurisdiction, who confirmed it is city code section 1.20J and K, which states medical marijuana establishments and marijuana establishments, which allows for only 2 retail stores in the city, which must be co-located within the same premises of an existing medical marijuana dispensary. There are currently 2 medical dispensaries and retail stores in the Carson City jurisdiction that have received their final license. Staff has communicated with Essence that there are no areas of concern, and has asked that Essence be prepared to discuss its progress at the board. It appears that Essence Henderson has not been able to perfect its adult use retail store license due to Carson City Code Section 1.20J and K. And approval of its extension request may be appropriate. However, the company has not provided any documentation or copies of correspondence showing its efforts to work with the Carson City to lift or amend the city code currently in place, despite some requests by staff for such supporting information. I am available for any questions, and my understanding is that Amanda Connor is present today, and Brendan Bloom is present via Zoom to give a brief presentation and address any questions you may have as well.
Please.
Good morning, Chairman, members of the board. Amanda Connor on behalf of the applicant, Essence Henderson LLC. As Mr. Gilbert indicated, I have Brendan Bloom, VP of Store Development for Green Thumb Industries with me via Zoom. We would ask that, like the members to the settlement agreement and the NRA DOT settlement, that Essence Henderson be afforded the same extension that was given in that settlement agreement, which gave 14 months from the time the moratorium is lifted in a local jurisdiction for the retail store to become operational. As Mr. Gilbert indicated, Carson City has a moratorium in place. Mr. Bloom can speak more to this, but Green Thumb Industries has been had communication through their lobbyist Will Adler regarding the moratorium in Carson City. But to date, Carson City has not taken steps to lift that moratorium, and therefore they're not able to begin the process of finalizing this license. Therefore, we kindly request that the moratorium or the extension be granted until the moratorium is lifted.
Any questions by board members?
Member Durrett, for the record, on this matter and other matters related to moratoriums, I would like to ask that we reach out to the local governments and get feedback from them on their moratoriums. Just any information they would like to provide about them, any feedback they'd like to provide. So I'd ask that for item A, B, and D, that we move these to a later agenda item until staff has discussed it and just received any feedback. They don't have to provide feedback if they don't want to, but I would like to give them the opportunity to provide feedback on these moratoriums. And yeah, that's it. Thank you.
Chairman, if I may, Member Durrett, I understand the concern. I believe Mr. Gilbert can confirm, but it is my understanding that staff has been in communication with Carson City specifically on this agenda item regarding their moratorium.
Thank you. I'm not going to ask for a vote at this point until we hear the other licensees in this. As to the item that Member Durrett put forth, as chair, I would ask our director and staff to reach out to our counties that have moratoriums and speak with them as best you can to update the board of kind of where they're at, this picture for us, which is separate from what Member Durrett has asked. As ESCO, we'll come back to it. We don't have a formal motion. But I'd like to hear from all the licensees.
Thank you, Chair, and we will proceed with that.
We have another.
Should I move on to agenda item 10B?
Yes.
Agenda item 10B is for Essence Tropicana LLC. Essence Tropicana LLC, Tropicana, was issued conditional adult use retail store license RD319 on December 5th, 2018, within the Henderson jurisdiction. On October 12th, 2020, the Cannabis Compliance Board issued a notice to Tropicana that its retail store facility must be inspected and approved for final licensure by the CCB and complete appropriate local government requirements no later than February 5th, 2022, or the license will expire. On August 9th, 2021, Tropicana, through its legal counsel, submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline. Specifically, Tropicana requested an extension for 14 months after the Henderson jurisdiction lifts its moratorium. In its request, management reported that Henderson jurisdiction currently has a moratorium on new adult use cannabis establishments. A CCB agent contacted the business operation manager for the city of Henderson, who confirmed Henderson currently has a co-location requirement for adult use and medical cannabis establishments. That's Henderson Code of Ordinance, Chapter 4.118.070B1. Staff has communicated to Tropicana that there are no areas of concern and has asked that the licensee be prepared to discuss its progress at the board meeting. It appears that Tropicana has not been able to perfect its adult use retail store license due to Henderson's Code of Ordinance, Chapter 4.118.070. An approval of its extension request may be appropriate. However, the company didn't provide any documentation or copies of correspondence showing its efforts to work with Henderson to lift or amend the city code currently in place, despite requests by staff for such supporting information. I'm available for any questions, and my understanding is that Amanda Connor is present today and Brendan Bloom is present via Zoom to give a brief presentation and address any questions you may have as well.
Go ahead, Ms.
Good morning, Chairman, members of the board. Amanda Connor on behalf of the applicant Essence Tropicana LLC. And with me via Zoom is Brendan Bloom, VP of Store Development for Green Thumb Industries, Inc. As Mr. Gilbert indicated, my client is asking for an extension of 14 months past the time Henderson lifts its moratorium to be treated equally as those in the settlement agreement of NRA DOT who were given similar extensions in jurisdictions that have moratoriums. Mr. Bloom can speak more to this, but with regards to communication with the city of Henderson regarding their moratorium, Essence Tropicana, along with other conditional retail store licenses in Henderson, have been working together with two lobbyists, Jay Brown and John Marciano, to work with City Council to address their concerns and hopefully get the moratorium lifted. Specifically, these licensees conducted a demand study that was provided to the city of Henderson. And it is our understanding that Mayor Marsh has reached out to Executive Director Klimas regarding licensees and some concerns she has regarding diversity in an attempt to see a resolution to lifting the moratorium. We would request that an extension be granted, like I said, 14 months after the moratorium is lifted to treat them like other conditional licensees in the city of Henderson. Thank you.
Thank you. If we can move to C at this time.
Chief Gilbert, you can proceed with C if you're ready.
Okay, thank you. Agenda item 10C is for Pure Tonic Concentrates LLC. Pure Tonic Concentrates LLC, Pure Tonic, was issued a conditional adult use retail store license, RD 457, on December 5th, 2018, within the Story County jurisdiction. On October 12th, 2020, the Cannabis Compliance Board issued a notice to Pure Tonic that their retail store facility must be inspected and approved for final licensure by the CCB and complete appropriate local government's requirements no later than February 5th, 2022, or the license will expire. On August 17th, 2021, Pure Tonic submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline for an allowance of additional time to perfect the license. In this request, management reported that Story County previously had prohibited cannabis activities until the county adopted Bill number 129, Ordinance 21-318 at the August 17th, 2021 Story County Board of County Commissioners meeting. The new ordinance allows for cannabis uses only at the Tahoe Reno Industrial Center and nowhere else in the county. On September 17th, 2021, Pure Tonic provided documentation supporting Story County's recent revisions to their regulations and ordinances. What they provided was a notice of rescission of prior approval of regulation and acceptance of new regulation, which was signed September 7th, 2021. They provided Story County zoning ordinance, chapter 17.10.049, defining cannabis establishment and cannabis paraphernalia, in chapter 17.37.030N, listing cannabis establishments as a permitted use. Also, they supplied Bill 129, Ordinance 21-318, which amends Story County Code to license cannabis uses. Pure Tonic has proceeded to submit their business license application, has chosen a site, and building planning is underway. After they receive their construction timeline, they request an extension of 18 months to July 5th, 2023, due to major supply chain and cost issues. Staff has communicated with Pure Tonics that there are no areas of concern and has asked that the licensee be prepared to discuss its progress at the board meeting. It appears that Pure Tonic has made best efforts to perfect its adult use retail store license, and approval of an extension from the February 5th, 2022 deadline would be appropriate. I'm available for any questions, and my understanding is that Jacob Ward is present via Zoom to give a brief presentation and address any questions you may have as well.
If we can have
Good.
that person come forward and speak.
Good morning, Mr. Chairman and members of the board. My name is Jake Ward. I'm co-owner and president of Pure Tonic Concentrates. Thank you for taking the time to consider our request to extend the February final inspection deadline for our retail license in Story County. Chief Gilbert's summary is thorough and accurate. The only thing that I would like to add is that it took nearly a year to go from a complete prohibition on all cannabis uses in Story County to where we're at today. So with that, I'd like to thank the Story County staff and the commissioners for all the work that they had put in to make it happen. They were dealing with a lot of very significant issues at the same time that we were trying to get this work done, and it's much appreciated that they were able to get it done in light of that. So with that, I'm here to answer any questions that you may have regarding this item.
Any members of the board have questions? That's a Pure Tonic. No questions? Thank you.
Thank you.
Okay, moving on to agenda item 10D, which is for Green Therapeutics LLC. Green Therapeutics LLC, Green Therapeutics, was issued a conditional adult use retail store license RD 273 on December 5th, 2018 within the Douglas County jurisdiction. On October 12th, 2020, the Cannabis Compliance Board issued a notice to Green Therapeutics that their retail store facility must be inspected and approved for final licensure by the CCB and complete appropriate local government requirements no later than February 5th, 2022, where the license will expire. On September 7th, 2021, Green Therapeutics submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline for an allowance of additional time to perfect the license. In its request, management reported that Douglas County jurisdiction currently had a moratorium on cannabis establishments. In an email to the CCB from Green Therapeutics dated October 12, 2021, they supplied a timeline of their efforts to work with county officials to change the county ordinance. Staff confirmed with Douglas County that Green Therapeutics did present to the Douglas County Commission on January 3rd of 2020, and there is a prohibition on cannabis establishments in the county as per ordinance number 2014-1418, section 3, 20.660.170. Staff has communicated to Green Therapeutics that there are no areas of concern and asked that the license be prepared to discuss its progress at the board meeting. It appears Green Therapeutics has made best efforts to perfect its adult use retail store license, and approval of an extension from the February 5th, 2022 deadline would be appropriate due to its efforts to perfect the license in Douglas County. I'm available for any questions, and my understanding that Rusty Graff and Paul Larson are present today to give a brief presentation and address any questions you may have.
Mr. Graft?
Madam Chair, or Chairman, members of the board. Green Therapeutics immediately tried to start and engage Douglas County in April of 2019. They went before the board. They hired Mr. Vanderpool to start lobbying the county to potentially change that moratorium. They have gotten so far as to recently retain additional representation in Douglas County and have approached the various commissioners. That's a 5-person commission. 2 are up in 2022, and then the other 3 are up in 2024. It is hoped that that moratorium will be changed in the next year or so in terms of the legislative process in front of Douglas County, and they seem to be receptive to that. And I would leave it to the director or Mr. Gilbert to give you further information.
Thank you.
Any other questions, I can field those.
If we have an additional speaker on this matter, if they wish to say anything for the record, please do so. Board members with any questions? Thank you.
Thank you, Mr. Chairman.
Let's move to E.
Agenda item 10E is for HH Sub 1 LLC. Helping Hands Wellness Center Incorporated, Helping Hands, was issued a conditional adult use retail store license, RD 548, on December 5th, 2018, within the City of Las Vegas jurisdiction. On October 12th, 2020, the Cannabis Compliance Board issued a notice to Helping Hands that their retail store facility must be inspected and approved for final licensure by the CCB and complete appropriate local government requirements no later than February 5th, 2022, or the license will expire. At the May 25th, 2022 CCB board meeting, transfer of interest request number 21050 submitted by Helping Hands was approved, transferring the conditional license for RD 548 to HH Sub 1 LLC, HH Sub. On October 4th, 2021, HH Sub submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline to August 2022. In the request, management reported that the certificate of occupancy should be completed on November 30th, 2021, and they will proceed with casework IT and completing the remaining items needed in preparation for inspection by the City of Las Vegas and the CCB after the certificate of occupancy is complete. In the project plan submitted by HH Sub, it shows a project opening date for the retail store on January 4th, 2022. In its request, management stated they wanted enough time to allow for inspections by the City of Las Vegas and the CCB, and requested a 6-month extension in case there were any delays in scheduling. Staff has communicated to HH Sub that there are no areas of concern and has asked the licensee to be prepared to discuss its progress at the board meeting. It appears HH Sub is making progress on the build out of the retail store and is currently on schedule to complete it by the deadline of February 5th, 2022. And approval of an extension would be appropriate in case HH Sub experiences any delays in the final phases of its build out. I'm available for any questions, and my understanding is that Jennifer Solis is present today and will be given a brief presentation and address any questions you may have as well.
Thank you, members of the board. Chairman, through you to the board. My name is Jennifer Solis for the record. I represent HH Sub 1 and 2. We are in our final build out for HH Sub 1 in the City of Las Vegas. I've submitted application with the city and have a follow-up appointment on Thursday. But some of our casework now has supply chain issues, and it is looking like it's going to be delayed by about a month. We're asking for a 6-month extension from you so that we can make sure that the supply chain issues can be solved and we can finish construction. And that's all. Thank you.
Questions by board members? None? Thank you very much.
Thank you, sir.
We've heard from our staff and we've heard from applicants as to these. It seems that we have two different kinds of requests. We have three because of the moratoriums. We're requesting extensions. We have two that are proceeding and need additional time to complete their build outs and inspections. I would say for the record as to the three with moratoriums, that what they were asking for, they were not part of the settlement that took place, but I have no opposition to extending their deadlines at minimum to February of 2023, 1 year. And hopefully within that period, we'll get a report back from our director, what's going on in this industry. But I'm not saying that because I don't wish to see them licensed in the future, but just we need to know what's going on and what's proposed. And by that point, we might even have some idea of what's happening on future legislative proposals with the legislature. As to our other two, Pure Tonic, they're proceeding, they wanted 18 months. I'd almost like to see granting the 18 months and having them just back on in 12 months, just for an update of what is going on with their action. And as to item E, H, and H, just flat giving them 12 months and see if they can get it done faster, hopefully, and they'll bring it back because I know they want to be open. But that's just my thoughts. That's not a motion at this point, just thoughts to see what other members are thinking before we get a motion.
Mr. Chairman, this is Member Nylander. Yeah, I agree. Just for consistency, maybe we should grant all 5 of these 12 months. Item number 4, or D, I guess it is, they're only asking for 6 months, but I don't see any harm in granting them 12. They're making progress on their build out. But those are just my initial thoughts as well. It's just to go with 1 year just for consistency and have them, they can easily come back for a status and request an additional extension if they needed to.
You're going to speak?
Yeah, Member Drat. I agree for the most part. I would just ask that A, B, and D be moved to the November 16 agenda so there is time to reach out to ask the local government specifically. I know staff has reached out to them to ask in general, are they compliant and other questions, but I would like just to give them the opportunity to foreclose that issue on the moratorium. Just, I would like specifically to reach out to find out what their, for example, well, I don't want to give examples because I don't know what they're going to say, but I want to know their thoughts on these moratoriums. Do they plan to never lift them? I think that would, I just think we need a little more information on those 3.
Member Young, do you have any words of wisdom?
That I don't know, but I support both you and essentially I think all of us are in agreement on the extension, and I certainly would understand. It'd be nice to hear what the local governments have to say. I just want to clarify, are we talking about a 12-month extension from the February 5th or 12 months from today's date, since there's some question from last time?
We'd be looking at least my understanding, since what they have right now is till February of 2022, we'd be looking at 12 months from 2022 to February of 2023.
I would support that. Thank you.
Having kind of gotten the feel, do we have a motion? And
I don't think my do it.
I would then craft a motion that, using the words of Member Nylander, that we extend the inspection deadlines that previously are to expire February of 2022 to February of 2023 as items A, B, C, D, and E. That is the motion.
I would second the motion, Mr. Chair.
We have a motion and we have a second. Any additional discussion? All in favor say aye.
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 The matter carries unanimously. The extension is to 2023 for all the parties. And as we said, it's an open-ended situation right now. For the two that are able to proceed, good luck. Hope you can get it done. And the one that's looking for 18 months, hopefully you'll have good things to tell us the next time we see as to getting the additional time so you can complete what you're proposing. For the other three, we are trying to gauge what's going on out there. It's not wanting to treat you any different than we really treated the settled parties. But at this point, we're not opposed because of the moratoriums to giving the year extension. But again, as Member Durrett said, it's something that we need to get a better handle on and get some information. So we're now asking staff to research that. And if we can now approval of resolutions, item number 11, fine licensures.
Thank you, Chair. Chief Gilbert will also present on agenda item number 11. So Chief Gilbert, when you're ready.
Agenda item 11A is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. We have two licenses to note today. Number one is for Cheyenne Medical LLC, RD 267. Cheyenne Medical LLC applied for a conditional adult use retail store license during the September 2018 application period held by the Department of Taxation. On December 5th, 2018, Cheyenne Medical LLC was granted a conditional license for an adult use retail store facility in Elko County. On September 1st, 2021, staff conducted a pre-opening inspection and audit of the facility located at 1868 Royal Drive in Jackpot, Nevada. The inspection audit results revealed no deficiencies with the NCCRs or Title 56 of the NRS. The statement of no deficiencies was issued on September 10th, 2021, demonstrating Cheyenne Medical LLC has met regulatory requirements to become operational. As a result, the CCB approved and issued final license to Cheyenne Medical LLC on October 5th, 2021 for an adult use retail store in Elko County jurisdiction. Item number 2 is for Helping Hands Wellness Center Incorporated, RD 546. Helping Hands Wellness applied for a conditional adult use cannabis retail store license during the September 2018 application period held by the Nevada Department of Taxation. On December 5th, 2018, Helping Hands Wellness was granted a conditional license for an adult use retail store facility in the North Las Vegas jurisdiction. At the May 25th, 2021 Cannabis Compliance Board meeting, transfer of interest request 21050 submitted by Helping Hands Wellness Center was approved, transferring the conditional license to HH Sub 2 LLC. On September 3rd, 2021, CCB staff conducted a pre-opening inspection and audit of the facility located at 150 East Centennial Parkway Suite 114 in North Las Vegas, Nevada. The inspection and audit results revealed no deficiencies with the NCCRs or Title 56 of NRS. A statement of no deficiencies was issued on September 13th, 2021, demonstrating HH Sub 2 LLC has met the regulatory requirements to become operational. As a result, the CCB approved and issued final license to HH Sub 2 LLC on October 5th, 2021 for an adult use retail store in the city of North Las Vegas. With that, Chair, members of the board, I'm happy to answer any questions.
Questions, board, as the action is taken. This is on for discussion only. Then that would move us to item 12, Cannabis Advisory Commission update and actions from our director.
Thank you, Chair. Agenda item number 12 is the updates and actions for the Advisory Commission. Reporting that the next meeting of the Advisory Commission has been scheduled for November 9th at 11 a.m. At this commission meeting, the commission will hear some of the recommendations and readouts from the subcommittees. There's been 3 subcommittees that have met a combined 10 meetings since August. So they've done a lot of work discussing and researching issues around consumption lounges. And so these 3 subcommittees will present their findings to the commission. The commission may take action to send some recommendations up to the board for the board to consider as the board moves forward with the promulgation process around consumption lounges. I would like to just state for the record my thanks to the subcommittee chairs for the work that they've done. As I mentioned, 10 meetings between the 3 subcommittees since August. It's a lot of work. And so I'd like to thank Assemblyman Steve Yeager, Advisory Commission member Aisha Goins, and Advisory Commission member Dr. Ginny Pearson for all of their work. That's what I have for the Advisory Commission. I'm happy to answer any questions from members of the board on that.
You mentioned sending things up, and that's for our consideration if I read the regulations.
That's correct. These are simply recommendations for us to consider as part of the process of consumption lounges, and that is the role of the Advisory Commission. And if you remember, Chair, the Advisory Commission is studying issues that the board asked them to as well.
Anything else on this issue that anyone wished to raise with the director? Hearing none. Now we move to the second part, which is item 13, just general briefing.
Great. Well, on consumption lounges, the topic of the day, just as a heads up, we are targeting a mid-December, either the first or second week of December, for a workshop, this board's workshop on consumption lounges, which will likely be NCCR 15. By that date, we should have some recommendations to consider as part of the process. And obviously, since the passage of the bill, CCB staff has been working incredibly hard on putting together a lot of the ins and outs of what will be required as part of a lounge program. So as I mentioned, beginning of December will be the first workshop on lounges. That's the plan. It comes as a natural midway point from the time the bill had passed and signed to when we kind of anticipated the first lounge opening, which would be sometime mid-year next year. So that date will also provide us a good gauge of where we're at on the timeline. Certainly look forward to public and industry participation in that. And then lastly, Chair, members of the board, on renewals, we talked about a similar issue last year as a bulk of our renewals come on June 30th for licensees. When we took over oversight, we had some administrative challenges with the renewals. There were licensees that hadn't paid in a number of years, et cetera. And there was just really kind of a lack of importance on paying on time, paying your tax bills, paying your time and effort bills. We've done and made significant headway this year. But as an update to you, on July, we had 24 entities. So that's over 34 licenses that had not paid. They were expired then. They were given 60 days to correct their deficiencies. And we shut off metric access after 30 days. By August 4th, there were only 4 entities that remained expired. And then by the end of 60 days, and then now 90 days, all but one came into compliance. Boulevard Medical LLC has surrendered its license as a result of non-payment and non-activity. Other than that, the majority of the licenses are in compliance, and we're able to move forward again with this year of operation. So with that, happy to answer any questions from members of the board.
Members of the board, questions or anything that they want to put forth? Just as indicated previously, we're asking you to look at issues related to moratoriums throughout our state for us. Additionally, I would put something in our northern Nevada or any place else. If you would just check with our locals in terms of their relationship in terms of cannabis with our Indian tribes to see if we have any issues that we need to make sure we get ahead of so we don't have problems going down the road with as to consumption lounges, reservations, or transportation of what they can legally grow on the reservation, wish to transport to other locales, just so we know when we can work out and get ahead of the storm and not have a storm. The other is just based on a news squib this morning. There was a report that there were a number of felony violations, misdemeanor violations, some other things out at the Electric Daisy event that just transpired this weekend. They didn't bother to give any breakdown whether those were related to controlled substance or legal medication or what it was about. It might be nice for us to kind of understand what those violations were, if they were just minor or not, just to have a better handle, since that's an issue that is somewhere down the road. Has some discussions about special. So just to begin to understand the field and what's going on out there.
Certainly, Chair.
Item 14 is our next meeting date, which we do have Thanksgiving coming up, which would be November 16th, 2021. That's the proposal. If board members have concerns or whatever, they need to get it into us so we can make allowances for posting of meeting date and whatnot, but tentatively it's November 16th, 2021. And items for future agendas. I know we're have some, the year end is moving fast. Now we move back to our public comment. We had one gentleman who started, if he wishes to give it another try, besides anyone else. Just take a deep breath and again, give us your name for the record, please.
J. Christopher Stokes. I'm with Smoke With, and it's actually a little blind spot that I wanted to make you aware of. I'm looking for investors. When you go to the compliance website, there says no alcohol specifically. But when we look at the actual LVMC, it says only if you're specifically authorized the licensee. This board has to specifically authorize. So what happens is I'm working to look at investors. They go to the board. They're like, they don't allow alcohol. What I want to do is kind of combine those. So it's cannabis with beer and wine, but we do no high potency concentrates. So we're not trying to over medicate our guests. So as far as that, that's kind of some clarity I would like to have as far as, is my business plan a coffee shop or is it a champagne bar? So that's kind of my public comment to that.
Thank you.
Thank you very much.
I just general comment, and I'm not going to comment on all public comments, but you need to understand that the Cannabis Board is We are regulated by Nevada revised statutes in the legislature. They allow us to regulate. We regulate cannabis only. The bills that was promulgated by the legislature gives our local incorporated cities and counties the ability to make regulations within that. And the prohibition you're talking about, I know the city of Las Vegas has said no alcohol in their facilities at this time. Subject to change, but so the local entities may be where your fight's at more so with us or dealing with legislators or future changes.
Okay, so the local entities. Thank you very much.
Other individuals with public comment for the record. That being the case.
Is there anyone in Carson City who wishes to provide public comment?
No public comment in Carson City.
Is that because of the snow in Carson City or not? With that, then, if we have nothing else for the day, unless there's an opposition by one of the members of the board, we're in adjournment. Thank you.
Very good.